from the appellant.
Your Honor, I'm Franklin Chansey from the Bradley County Bar. Request to reserve 3 minutes, please.
That'll be fine.
Your Honor, this is a apparently long and twisted domestic relations case, which appears to have lasted 5 or 6 years before it managed to get to the Court of Appeals. And it goes back to a petition to modify that had been filed by the mother in the case all the way back in 2016. And that petition alleged that there was an educational harm to the minor child because of a present equal co-parenting arrangement. The court conducted an interim hearing and agreed with that and modified the parenting plan to reduce the father's time to every other weekend plus one overnight in an alternate week. A couple of years goes by, for whatever reason, and I'm pleased to say I was not part of that part of the process, but before other hearings took place. And in that period of time, it appears that the father was involved in at least 2 incidents that raised domestic violence concerns. One in which he and a paramour were both charged with domestic violence, but which were later dropped, dismissed, and expunged. And then a second episode that happened a year and a half later. All during this time, the father was exercising this every other weekend visitation. When the matter came on for final hearing, the trial court heard proof about this, and that proof included the following facts, which I think aren't disputed. The first is that the educational situation had improved following the modification of the parenting plan, and that the child was doing well, still working hard, still had a few issues to address, but all that had gotten better. Secondarily, the proof was that the child was happy, well-adjusted, loved both of her parents, and there was no evidence presented to the court that the child had been exposed to any of this alleged domestic violence. In fact, I think it's in the record that a guardian ad litem reported that the child knew nothing about the legal proceedings in this case whatsoever, that the parents had actually done a good job of keeping her out of this. So at the close of the hearing, or some period of time later, the court issued a decision, and primarily it's the court's application of TCA 36-6-406A that's at issue here. The court found that these domestic violence incidents represented a pattern of physical abuse on the part of the father. And he applied that on the basis that he felt like there was a possibility, and that's the only way I can describe it, a possibility that the father's controlling nature with women could adversely affect the child in the future. There was no expert proof presented whatsoever that the child had a negative impact on him, or even any proof that the child was aware of any of these issues. And so consequently, we think the court applied the legal standard incorrectly. The way I understand the rule is that the court must find first that a pattern of physical or emotional abuse of the parent, the child, or a person living with the child has occurred. And once that's occurred, that specific findings are made, the court must find that the conduct, quote, would cause harm to the child. And then the court's supposed to find the least restrictive alternative available. So in this particular case, the court didn't find that this would harm the child. The court found that it might harm the child. Again, no expert testimony was presented to that effect. So when the court then looked at the remedies that were available in this circumstance, the court did something which I would describe as kind of peculiar. Although the child had been going every other weekend overnights for a couple of years at that point with the father, the court decided to restrict the father's time to an 8-hour block on Saturdays and Sundays each week. And again talked about how he was fearful that the father would somehow project this controlling nature on women onto the child. Well, court's remedy doesn't seem to address that question at all, even if you do accept that the court's discretion allowed him to do that. All the court took away was the ability of the child to sleep in the father's home.
Counsel, excuse me for interrupting. As I understand, at some point during the litigation, there was an agreed order that was entered with respect to co-parenting time. How did that agreed order impact the residential schedule and co-parenting time?
It reduced the Wednesday on the alternate weeks to a FaceTime call, and then it also said that he would exercise his time at a brother's house. Although it didn't say it was strictly supervised, it says that's where he'll exercise it. So that was the order that was in effect at the time of the final hearing in the case. So what the court didn't do...
Through that agreed order, then, was there an agreement or a stipulation that the co-parenting time should be modified or changed?
I think the court had found at that point that a material change in circumstances had occurred, and had already at that point modified the parenting time from equal co-parenting week about to this every other weekend and Wednesday arrangement. This restricted it a little bit further. I agree with that. But in this particular case, the court's ruling doesn't even seem to address the issues that the court said it was concerned about. The court could have said, for example, you're not allowed to have any paramours present. That would be something that would be consistent with the court's analysis in the case, at least. Or the court could have said, no, it's got to be strictly supervised when you're around the child. That didn't happen either. The court didn't restrict the father's interaction with the child at all during his 8 hours each Saturday and each Sunday every other week that he was able to exercise with the child. He just simply said the child can't sleep at your house, with no explanation for how that relates to this. Now, the court is required under the legal standard to provide the least restrictive alternative available in the case because of the directive to try to maximize the child's time with each parent to the extent possible and when it's in the best interest. So what we think in this case is that the court stretched, if you will, the ability under 36-406A to craft this remedy. The facts are that the harm that had been demonstrated by the court to the court had already been addressed. The educational impact on the child was something that was presented at the initial hearing all the way back then, and the court took that into consideration and modified the parenting time. The court then, and this is from the court's order, left the proof open for expert testimony of any emotional impact on the child. Well, no expert testimony was ever presented in this hearing about any emotional impact on this child whatsoever. A teacher came and testified that she had a bad experience with the father in kindergarten. A first grade teacher then came and testified that she had no problems with the father whatsoever in kindergarten. Multiple witnesses came and testified that he had never behaved inappropriately around the child. In fact, even the alleged victim of the domestic violence said, no, I never saw him do anything around his child that caused me any concern. So respectfully, all we're suggesting to the court is that its application of the statute did not apply the legal standard in an appropriate way. Question?
You have your time for rebuttal. Hear from the appellee.
Good morning. I'm Randy Sellers, the Bradley County Bar. I represent Ms. McDonald in this matter. First, I wanted to address Your Honor's question about the agreed order. I want to put it in context as to when that occurred. That agreed order came about as a result of the second, what we allege, domestic violence matter that occurred with another girlfriend, and that the order that resulted from that agreed order, which did reduce time, came after the hearing where the teacher testified, where Judge Bucket first reduced co-parenting. And when I say first reduced, the agreed order reduced it further with Dad's agreement. And specifically what that agreed order said was that he would still have his every other weekends. It would be handled at his brother's home. He did have previously from Judge Puckett a Wednesday overnight to Thursday morning. That was taken out, and the FaceTime was put in for on the Wednesdays, each and every Wednesday. There were to be no females that he was involved with at the visitations, and also that he would do an A&D assessment, which he's never done throughout this entire proceeding from 16 forward, despite repeated requests by the court to do that, not requests, directives. So he himself agreed to reduce this co-parenting, and I think that's important because the only hearing after that was the one that culminated on September 14th and 15th of 2021, where the judge ultimately made the ruling that since these other things have taken place in the interim, here's what I believe is in the child's best interest. So that's to answer Your Honor's question about the agreed order a little bit. I want to go back and first indicate, as I have repeatedly stated in my brief, that this case has had, by my best count, 4 or 5 hearings. And the first one was in 2016, which was left open by Judge Puckett for either party to bring forth other proof that they wanted to bring forth on this matter. And remember, this man's co-parenting started out at week on, week off. And each time something else arose that caused this second, third, fourth hearing, and then ultimately the final hearing, it was as a result of Dad's conduct. It was repeated. It was repeated conduct that involved anger, that involved alleged abuse of women, that it involved alleged abuse of women with their children present, one time of which the child in this case was present. That's the one he had the altercation with in November, December of 18, which resulted in the second hearing. He had an altercation with his girlfriend. They were both charged with domestic violence. They were both arrested. The child was there in his care. Now, they're going to say, well, the child was in the bathtub when this happened. But then during the first of the week, Dad hands the child off to his brother, who's a deputy sheriff, and he basically hides the child from Mom for 2 or 3 days, claiming that the child was sick. And they even proffered a after-the-fact doctor's excuse to try to prove that. So that's the kind of shenanigans or conduct that's going on with Dad. So there's the second hearing. Then we have a third hearing that involves the teacher, where the teacher says that basically she's afraid to meet with Mr. Coffel because of his hostility and anger and yelling at her simply because Mom, who was the decision maker, by the way, on education and other issues, believed that the child needed tutoring and other types of educational help that Dad disagreed with. And Dad disagreed with vociferously. And it caused the principal of the school to say, teacher, if you have to, I wouldn't meet with Mr. Coffel unless a policeman is present at that meeting. The judge did, by the way, find that that teacher was an expert in the realm of education by virtue of being this child's teacher, and did find that there was an impact that his conduct had on the child in preventing the child from being properly enrolled in tutoring, that type of thing.
Counsel, excuse me for interrupting.
Yes.
As I understand appellant's position, or one aspect of the appellant's position is that the trial court improperly applied the statute 406. Could you address that, please?
Yes. TCA 36 6 let me find the correct number. (36.6.406). Judge Puckett used subsection A, and then he went to subsection 2, and used subsection D, 5, 7, and 8. So what does all that say? He went through and made very specific findings that allowed him, as the statute says, to restrict or limit parenting plan if any of the following conduct has been engaged in by the parent. Well, what's that? Number one, physical or sexual abuse or a pattern of emotional abuse of the parent, child, or of another person living with that child as divided by 363601. But then more importantly, it says, next, a parent's involvement or conduct may have an adverse effect on child's best interest, and the court may preclude, not just limit, preclude or limit any provisions of a parenting plan if any of the following factors are found to exist after hearing. Judge Puckett specifically uses subsection D, 5, 7, and 8 to make that finding. 5 indicates the abusive use of conflict by the parent that creates a danger of damage to the child's psychological development. 7, parent's criminal convictions, which he admitted he had criminal convictions as a result of his conflict with Mrs. R, the second lady that he had a scenario with, where he threw according to him, a 200-pound coffee table through a window with her child present, and said she did it. And then 8, such other factors or conduct as the court expressly finds adverse to the best interest of the child. The case I could find, Your Honor, that deals with that statute and with restricting time, 2 very important cases. One is on page 42 of my brief, the Kelly v. Kelly case, that talks about, and Your Honors have heard this many, many times, that the court will not reevaluate a trial judge's assessment of a witness credibility, goes to credibility. And then the Birchfield case, which I cite at the Court of Appeals 2019 case, that says that the court can use 36, it specifically uses this statute, 366406D, which is what I've been reading from, to restrict or limit co-parenting time, where in that case it specifically dealt with father engaging in conduct that constituted an abusive use of conflict. And that fits this case perfect, because the case at bar.
Did the trial court make specific credibility determinations?
Absolutely, yeah, early on and repeatedly. The references in my brief as to the judge in the statement of facts, finding that mother's testimony, that father's testimony was not credible. That's in the very first hearing. And then later on in his final ruling, which, by the way, I've extracted and set out on page 23 through 26 of my brief, very, very specific findings by Judge Puckett. I think there's about 27 or 28 different findings where he repeatedly uses the statute I've been referring to, along with other statutes that, as we know, talk to us about definitions and also other things that a judge should consider in coming up with a parenting plan. I want to go back to something before I forget.
Well, let me ask you something before you turn.
Yes, sir.
The father's first issues where the trial court abused discretion in fashioning a parenting plan, denying father any overnight co-parenting plan, specifically as the trial court's denying him any overnight co-parenting plan. Did the trial court say why? I mean, he allowed the father visitation, but not overnight.
Well, all I can say is every time that well, not all I can say, but part of what I
There's always more a lawyer can say
in the brief, but part of that it includes that every time we went back to court, father had been involved in some new conflict that always from the very beginning involved some type of issues that he has with women in general.
Well, but specifically, father, you get time during the day, but no overnight. Did the trial court say why no overnight?
If we look at the findings, Your Honor, let me go back to that on
Sure.
page 23. And again, this is where there was 29 of those, and the court would have to review it. Where at the very end, after 28 findings, he says, as a result, the trial court indicates that father would not have any overnight co-parenting and was to exercise day visits, etc., as stated. He uses the abusive use of conflict.
I understand.
Yeah, he made findings.
I understand
your question, Your Honor.
my findings, but I'm trying to figure out why it's okay for father to have daytime visitation, but no overnight visitation.
Well, he discussed the fact that he goes back partly to the scenario with the teachers and principal, where he talked about the educational effect that that's had on the child. I can only presume that mom was in charge of homework, of all school activities, that type of thing, and I know it's on weekends, but the court believed that the control issues, that the educational issues, that the abuse issues, the conflict, the fact that he'd had this criminal charge, the fact that, again, repeatedly, every time we come to court, there's something new to further restrict his co-parenting time, Your Honor. And again, that Birchfield case does say that that is proper under this statute. That's probably the most important case that I found on this topic, if the court will review that. I do want to remember, again, to point out that a lot of what appellant says were factual findings, or like in our statement of facts, for the first 3 hearings, there are no transcripts submitted to this court. The first hearing was from 11/11/16, had a very important set of rulings in it. All you have is what the appellant surmises are the facts, because there's no transcript for that hearing. When we return in 2018 with the first domestic violence, there's no transcript of that hearing produced to this court. So anything that they say is their interpretation of what the facts were that caused the judge to rule like he did in those interim orders along the way have nothing to back them with. There's no transcript for this court to look at. The third hearing, there's no transcript for this court to look at. That's the one with the teacher. Then we go to the agreed order in the summer of 2020, and no transcript yet because there was no hearing. There was an agreed order announced after an application for emergency relief. So the first transcript you're going to say is from the very first hearing, or the very last hearing of September 14th and 15th of 2021. So I don't think that there's any way that they can say, well, the judge didn't do this or didn't do that. How do we know that? How do we know if his findings were correct or supported by factual bases? We don't, because, again, there's no transcript. They use the orders even as attachments to their brief. Those orders aren't, I don't think, in the technical record, the 3 orders from the 3 hearings before that final hearing. So, again, I think that's significant in whether or not they can truly show an abuse of discretion without having a full look at this case, Your Honor. I do want to remember that to remind the court, my client would say that if this court affirms the decision of Judge Puckett that I thought was very well reasoned and, again, very much so substantiated by factual bases, that she be awarded an attorney fee on appeal as well, in Your Honor's discretion. Does the court have any other questions of me about? Okay, thank you.
I hear none. Hear from the appellant rebuttal.
Your Honor, we are pleased that the appellee is relying upon the Birchfield case, because I think it is instructive for the court. I'm actually quoting from the appellee's brief here as they quote Birchfield. We agree with the trial court's statements that the children are noticing and internalizing this conflict, and it creates a danger of damage to their psychological development. The children need the parties to coexist without continual conflict. That's what's different in this case. The proof that's in the record is that the child wasn't exposed to any conflict, that there's no evidence before the court that the child was exposed to anything that my client did or any other conflict between these parties. The proof is the child is well-adjusted, happy, and loves both parents. So the Birchfield case is part of our argument here. As the court pointed out, and I'd like to just point out a couple of things in the court's decision here. On page 21 of the court's ruling, the transcript of that, and I'm quoting, "If he's able to manipulate women, he's also capable to manipulate his child to her own harm." Now, have I heard any proof about that? No. Going further down, I did not accept Mrs. Chase as an expert on comparative fitness. I didn't accept her as an expert. I'm going to make this decision based on something other than expert opinion in this case. The fact is, there was no proof presented to the court of any adverse impact to the child from these alleged acts of domestic violence that involved somebody other than the child's mother. Nonetheless, as the court correctly questioned just a moment ago, Judge Schweine, the court is required under the Rudd decision, which I think controls this, to look for the least restrictive alternative. And we're not arguing that the court can't have reduced his time. We're saying that the result that it came up with, one, wasn't supported by the evidence, and two, it's not the least restrictive alternative. There is no explanation in the record for why overnights were taken away. None whatsoever. It just says, I'm going to do that. Even the guardian ad litem had recommended the continuing the overnights during the weekend. That was not any proof presented that the child was sleeping in the father's home was going to cause problems for the child. Instead, the court created this twisted rationale to require the father to get up in Bradley County in the morning, drive to Hamilton County, get the child, drive back to Bradley County, and 8 hours later drive back to Hamilton County again before coming back to Bradley County and getting up the next day and doing it all over again. No explanation at all for why that would be beneficial to the child or why it's necessary. So respectfully, we think that is abuse of discretion in this case.
Court's thanks to counsel for both sides. Thank you for your arguments this morning and the briefs. Call the next case, please.